part of the record and part of the basis of decision making. So there's a public comment period, but that's just when you're taking public comment, and so you close that, and then you have a process by which you determine what you heard, and then make decisions, and then you send it to us, but the whole record is still open. Would be mine, but again, I'll leave that to the attorney.
You won't get there.
Because I know some people will probably take real issue to the word just public comment.
Oh, I'm sorry, yeah, especially that's my job, I mean, yeah, but in terms of the whole broad,
Because
within the
people
legal
will
process
want
and
to weigh in.
complexity of the process.
They will want to continue to provide information that as we talk here and they go, wait, they don't know about this, or they're lacking that, and everyone's quiet. And we kind of consider.
Are we still on question two?
Well, I if I could just pull back and Phil's question, is just to kind of bring closure to that. You asked, can you tell us where, so I would say, is, again, we talked about your process, now we're in this different phase, and I would offer that if you want, we've been set up something for our staff to work with yours, we can bring in some of these experts who have, can bring in others, so that's some information into that process, and we can have that conversation together. I think that's the way we like to do it.
Well, I just wanted to bring up a couple other points on that shoreline issue, is that you have to stay 1,500 feet away from the sanctuary like a protection island. You have to stay out of shipping lanes. We have shipping lanes that went right down to Seattle. And not only down to Seattle, we have the Navy shipping lanes that cuts across Port Townsend Bay. It'd be a real interesting study.
I think that's the challenge in front of us, is to look at the uses, look at the environmental conditions, and see what makes sense in terms of siting this use.
And I think we actually did cover this about question number 3 here. What documents does Ecology rely upon for determination that in-water finfish aquaculture can be operated with no unmitigatable impacts to surrounding resources? We covered these. Can in-water finfish aquaculture operations prevent the release of viruses? What documents are contained in the record? Can the record be expanded? Does it require additional public review? Does exploring existing regulations constitute expanding the record? Are there limits to what information the county and Ecology can consider? So I guess that is one of the things we really need you to get back to us on what your position is on that. In terms of what the record actually is, and can it expand, and how can the public impact that as well?
Different local governments deal with changes that required changes, funding required changes differently, but many of them more than a public meeting and a public comment period.
Right.
And you held one in July of 2011, I think. But does the county commissioners feel like that very first question, number 3, was answered?
You mean 3A?
3A?
No, the question above 3A, that's in 3.
Have we heard it? If you don't know that back, I think what I would say to that is what I said at the beginning, is we don't have a lot of expertise on our staff to do it, so we reached out to our certain federal agencies. So I can't say that one particular document we're looking at, say this is the document that says what you're saying, or this supports our position. I think we're looking for the advice and guidance and recommendations of our agencies with expertise. I think, and so NOAA's example, NOAA's letter that they sent to us, I think is one example, where they've done that. They've given us their advice. They cited some references in there, which I think you could say are part of that, supporting documentation, but it's through our collegial
Do you
relations.
typically get that advice in writing, or is it more of an oral thing, it's sort of a back and forth thing?
Well, I think when it's an issue that's at a level like this, we would try to get it in writing.
I think we'd appreciate any kind of bibliography you can organize in that regard, or Yeah.
Well, part of what we did was we relied on, to some degree, we handed the bibliography that you all produced, and we handed that to the federal agency. To know and ask them, said, here's what the county has looked at, so, I'm not sure if there's anything in addition to that that we could rely on other than, I think we heard that, it's noted in that letter, and some new work that's coming out, that it was,
We do have an effort to look more broadly at environmental impacts of net pens and models and how well they react from a scientific standpoint, and that's geared more toward the warm water rather than some on it. But germane. I would like to say also that this isn't our day job. Our day job is to be in the lab creating the information, and these kind of requests take a lot of effort, and it's not something we're good at. And quite honestly, I don't understand the politics or the legal ramifications. I guess the one joy I have is I don't care what the public thinks, I care what the data says. So we're really focused more around the science, not the politics of the issues. So to do these things, it's out of our comfort zone, but we're happy to help whenever we can.
Well, to make you more out of your comfort zone, I've got a question about NOAA's technical document, draft aquaculture policy that was written in February 2011. Technical document, number 49, I think, that says all of the environmental challenges to aquaculture listed in NOAA's draft policy, this is the title of the quote, dated February 2011, are, quote, nutrient and their concerns or challenges. Their challenges are, quote, nutrient and chemical waste, water use demands, aquatic animal diseases and invasive species, protected and sensitive marine areas, potential competition and genetic effect on wild species, effect on endangered or protected species, effects on habitat for other species, and use of forage for aquatic meats. These were all the risks you considered in aquaculture in February 2011. And I think that Ecology has a copy of that as well. And then I find it interesting that it was rewritten. Number 53, aquaculture policy number 53 was rewritten this fall. Basically saying everything is not now a challenge, but it's low risk. And I just, do you know anything about those two documents and how it went from challenge to low risk?
I don't really remember anything in 2011. I'd have to take a look at that. But when you do a risk type assessment, what you do is you throw up the worst possible things that can happen, and then you go through evaluating whether in fact that is reasonable or not. So I don't see that there's a consistency between these stuff.
Okay. I do.
Well, that kind of goes back, and this jumps down to another question, actually. Number 8, we did this back in a lot of our work back in 2009 on this. And we're looking at 2011 information, at the time, Whatcom County had an approved shoreline management program, and they just allowed, and we copied some of their language actually, limited, very limited use of net pens for enhancement purposes of existing salmon runs. And frankly, had difficulty seeing our situation as being significantly different, and wondering how Ecology approved that one and is not approving ours.
So I will get the undesirable task of answering that question.
Okay.
And we made a note of this when we met with the county commissioners back last spring, I think. Commissioner Johnson was there at the time. We basically told them we missed this. It was not a big issue in Whatcom County. There was not a big outcry on either side of the issue. It was the first master program that came in under the new shoreline guidelines. There was a lot of new in it overall. And we just missed this issue. And so I think what I would tell you is that if we were looking at Whatcom County's submittal today, we would be having the same conversation we're having with you. Instead, that we approved that master program at the time, and we'll look to future updates to be evaluated. It's not a comfortable answer to give, but
Appreciate that. It's also part of our, that approval is part of our record, and it's part of our consideration all through this. And that's one of the reasons I started thinking, well, maybe that work is even in Jefferson County, just like Whatcom County, right, for the next update. Rather than this one.
yeah, I think we've been clear on where we are on that with you. And I think it's important to note here, it hasn't really come up yet, but we are, part of this is our agency's interpretation and implementation of the state authority that we are charged with carrying forth in partnership with local governments. And we do this work with our own expertise, we do this work with the advice of our attorneys. And I think we're pretty clear on this, that we feel like given if we approve the master program here, that it would be subject to appeal and that we would be in a difficult position. So that's part of the calculus of our decision.
I think another piece that hasn't been spoken to, but is part of Ecology's statewide consideration role, is that we started out with Whatcom, and now Jefferson has proposed prohibiting net pen agriculture. And what if, one after another, other jurisdictions follow suit? All of a sudden, the entire inland estuary becomes off limits to aquaculture based on a state law that considers that a preferred use. So that's a real legal concern that we have to take into account. Now, Brian might want to say more or not.
No, I think capture this is part of the challenge of working in a setting that has, is driven really from the bottom up in sort of response to these overarching guidelines. Is how do you make sure you maintain preferred uses when the authorities being carried out by a number of different jurisdictions.
So basically, the reason you're not going to allow the prohibition is because you don't want us to set a precedent.
That wasn't necessarily the point. The point is that part of Ecology's obligation under the Shoreline Management Act is to look at broad state regulations. And so do we want a state with no net in aquaculture? And so we have to consider that question as part of our obligation. And so it is, our part of our role is to look at how all these SMPs sort of add up in a number of different ways. So that you don't end up excluding business on a statewide basis.
I think that's another one of these uncomfortable questions to answer, because it does sound a lot like, if we let you do it, we'll have to let everybody do it. And I think we've all encountered situations where supervisors of one sort or another have said that. It seems to be too broad. One of the, I've been looking for it here, and I can't find it right now. Jeff, you may remember this. We did get a letter from Mr. Stuart, which said, in essence, we don't want you to create a situation in which you have a de facto prohibition on net pens because you only allow net pens in areas which are impractical. And this creates kind of a bind, because it may very well be that the areas in which it's scientifically valid or safe to have net pens are also impractical, as has been mentioned, where it would interfere with navigation, or where there would be perhaps an outcry from the population that it's creating too much of a aesthetic impact. And how can we address that if by chance, or just by the nature of things, the very areas in which it would be safe to have net pens are impractical? It is a de facto prohibition. How can we avoid that?
Well, again, I think the correspondence I think you are referring to was not from Director Stuart, but was from me to Michelle. And I was,
Sent email?
Yeah, it was an email correspondence, and I was trying to explain our policy team having met and discussed the Jefferson County situation and how it could be carried forward. And one part of that conversation was this de facto prohibition that we have been advised must be avoided. And I think the answer, John, to your question is that the conditional use permitting approach is the way that you engage in that difficult. You know, you're looking at site-by-site particular environmental conditions in relation to a particular proposal for an operation. And if any, and that's why we was in the, I think at the Jamestown meeting a week or so back, I was talking about the use of prohibition in the context of the Shoreline Master Program being basically the strongest tool, and one that should only be used where it's absolutely necessary and appropriate, and should be used very sparingly. And it's our view, again, it is an interpretation, but it's our view that this is a case where it's not appropriate to call for prohibition. It is appropriate to site by site look at the particular issues and find, does it work, doesn't it work? Remembering that the shoreline regulation, the shoreline program is only one part of a much larger regulatory, there's a lot of different regulatory programs that affect whether you can do a given operation. So saying in the shoreline program, outright prohibition throughout the jurisdiction is a sweeping statement, and it has to be consistent with state law. And that's our take on it.